after extensive negotiation, can, despite the fact that they agreed in terms to the particular provision, is held by the law to be unenforceable by reason of being a penalty. The cases are replete with words of wisdom saying that it's an exceptional jurisdiction to be exercised. There has to be good reason to require judicial intervention, and the language we'll hear about is that the provision has to be extravagant or unconscionable and not just lacking in proportion to the event that gives rise to it, but being out of all proportion to it. Now, all those words are easy to say, but what I have found is that when you're confronted with the proposition that a particular clause is a penalty, and in the commercial list it always arises in a commercial context, and as I say, usually in circumstances where well-resourced litigants have negotiated the provision in question, what's required really is an evaluative judgment that really is not capable of logical, let alone arithmetical justification. It's not quite the vibe of the thing, but it's not far off it in lots of ways. And what I'm hoping to do is to show that that's the practical situation that we face. It really means just the practical situation that any transactional lawyers here face when you are creating and there's litigation. And at the end, I've got a little checklist that might be useful to those who are in that position. So where are we going? I'm going to take you through cases with which I'm sure you're familiar, Dunlop, Andrews and Pacquiao itself. But then deal with three cases where in more recent times we have had to, and I really mean I have had to, apply the principles to particular facts. And this is not a scarring exercise because in one of the cases I was overturned, so I want to reveal to you what I have found and what I still think was arguably correct. But when you see the calibre of the bench that overturned me, you can see that I must be wrong. All right, so next slide. All right, the background is, well, before we get to that, a background has been, a penalty has been described as Sir Anthony Mason and Sir William Dean did there. What you normally have to find for a clause to be capable of being a penalty is first a primary stipulation in favour of a party, and then a secondary stipulation which will be engaged if the primary stipulation is not satisfied, and that imposes upon the other party some additional detriment, and that's what is said to be the penalty. The primary stipulation is normally the payment of money, and the secondary stipulation is often the payment of money, but as you'll see in the case that we come to, the secondary stipulation, that is a thing that is to follow if there's been a default or something like that, may not be a payment of money. And the consequence of all that is, if the conclusion that is reached is that the provision is a penalty, is it's unenforceable. All right, so next one, please. So we've all heard of Lord Dunedin's speech in the Dunlop pneumatic tyre case back in 1915, and for those of us like Bernie Coles and I who were at law school, this was the law then, even Pritchard maybe. And the expression that was commonly used and still is used in this area of discourse includes the ones you can see there, whether the punitive penalty represents a genuine pre-estimate of damage likely to be suffered, and the words I've mentioned earlier, whether it's extravagant, whether it's unconscionable, and whether the burden imposed upon the party that claims the provision is a penalty is greater than the loss that the person in whose favour the provision is could conceivably think could have followed from the breach. Andrews was one of the big cases the High Court's decided about this. In Andrews, it was a class action, as many of you may know, against the ANZ Bank, dealing with late fees and over the limit fees. I think we can all remember seeing in our bank statements, if ever we ever did overdraw them or make a payment late, a fee would suddenly appear. And the issue in Andrews was that the bank wasn't suggesting that the customer was in default by making a late payment or overdrawing an account, but nonetheless charged these fees without notice on the occurrence of those events, which, as I say, were not said to be breaches of the contract. In other words, there was no obligation on the customer legally enforceable to not make a late payment or to not overdraw. And the case was being litigated in the federal court, and there was removed, as it were, to the High Court the question of whether or not a provision which enabled the bank to make these late payment and over limit fees was capable of being a penalty when there was no breach by the customer of his obligations to the bank that gave rise to them. And the decision of the High Court simply was that the fact that the fees were charged, so the fact that the fees were not charged upon a breach of contract did not itself render the fees incapable of being characterised as a penalty. Now, what I haven't looked at and don't remember is whether ultimately, when the matter went back to the federal court, these fees were held to be penalties. Does anyone know? I imagine, looking at what happened in Pacheco, the answer would be no. But anyway, what Andrews stands for is that you don't need to have a breach of contract for the penalty doctrine to be enlivened. Pacheco, though, with a similar case, there was a late payment fee of $35 for failing to make a minimum monthly payment, and was held not to be a penalty. Justice Gordon, as the trial judge, said it was. The full court of the federal court, I think Chief Justice Alsop and two others, said it was not. And the High Court 4-1, Nettle J dissenting, said it was not. A very good summary of, there's some material there about what Pacheco says, but where I always go to distill what happened in Pacheco is to go to what's on the next slide, which is what Justice McDougall did to summarise very handily. Can I suggest what the principles are? And they are these 6 ones: that what Lord Dunedin said in Dunlop, which we, many of us learned about at law school, are not rules of law, but they're distillations of principle. I'm not quite sure what the distinction between those two things is, so far as a trial judge is concerned. But the essence is that the putative penalty must be a collateral stipulation, the purpose of which is to punish the other party and thereby compel performance. So it's not enough. The High Court said that the real object was to make sure that the counterparty complied with his or her contractual obligations. If the purpose is to punish, to give that result, then it can be a penalty. And what the High Court said, as summarised by Justice McDougall, is that one way of testing that is whether the provision is extravagant, out of all proportion to the damage which might follow from the failure to comply with the primary stipulation. And the next point is that the damage that the person who wants to enforce the putative penalty provision says it might suffer is not limited to damages which would be recoverable on a breach of contract case against the person to whom the putative penalty is aimed. Next point is the analysis is not at the time of the breach, and that's an important thing to bear in mind. The analysis is at the time of the contract. So the question is, was the provision penal at the date of contract? And mere disproportion is not enough. And in Ringrose, the High Court said it's not enough that the provision is lacking in proportion. It's got to be out of all proportion. So, The words used come easily to hand. The question is how to apply them to particular circumstances. And obviously what we as trial judges have to do is to compare the obligation, whether it be contractually enforceable or not, under the contract that is sought to be enforced by reference to the putative penalty, the interests that are sought to be protected by the clause in question, and then the consequences to the counterparty of the enforcement of the penalty in terms. And as I say, that often is really an evaluative analysis, which often means one does little more to say, well, here's what the effect of the provision is. I think it is or isn't unconscionable, out of all proportion, etc. So let me give you some examples. And two of these are cases I've done recently, and one is a case that occurred in Queensland, and I have these to provide you some practical insight as to how these things work. In K and Play Up, the facts were a sale of a business, in effect. Mr. K had shares in a software company, and he sold those shares to someone else and thereby sold the business. And the consideration, which was some $1.6 million, was to be paid in two parts, one on exchange of contracts, that it was $600,000, but the balance of $1 million was to be paid over 2 years by monthly instalments, unsecured. So the evidence showed that Mr. K was very concerned about what his position would be if exposed as an unsecured creditor over 2 years, having sold the business. And so the deal he did was, well, I will agree not to compete with the business I'm selling for that 24-month period, provided that you, buyer, make these payments to me every month or within 7 days of the month. So Mr. K said, and I remember hearing him say this, he said, I would not have entered this transaction if I had not had that provision, if I had not been able to say, if you don't pay me on time with a 7-day grace period for these 24 monthly instalments, then I will feel free to compete with the business that I'm selling to you. And he said, his language was, it's a deal breaker. I wouldn't have entered the deal. And the evidence also was there were extensive discussions. Both sides were very well resourced, and that was the deal they did. Things went pear-shaped, and it was said in the context of litigation that provision was void as a penalty. Now, I held, although it was obiter, I held that for the reasons really I've outlined, I didn't think it was a penalty. I accepted and found the consequences of default were severe, because it meant that Mr. K, who had hitherto agreed not to compete with the business he was selling, could compete again if, and this is the problem, I think, any one of those 24 instalments was not made. I also found that, and this wasn't challenged, that the sole, if not the predominant purpose from Mr. K's point of view of having this clause in the contract was to focus the corporate mind of the buyer on paying. There was an appeal. Paul Brereton, Rob McFarlane and Caroline Simpson, so strong bench, as if there's any other sort, of course, up there, in case this gets out. Accepted that Mr. K had a legitimate interest on being paid in time, and accepted that this contract had been negotiated under between well-resourced parties, well-advised parties. But what Paul Brereton pointed out, and I can see the point, was that the effect of the clause was that if any one of those 24 payments, or if any part of any one of those 24 payments had not been made, then on the black letter reading of the contract, the non-compete clause went. So what His Honour said was, well, if there'd been a default in total of the first payment, then it may be that the avoidance of their non-compete promise might not have been out of proportion. But if the default had been $10 short, a day late on the last of the 24 instalments, it would be extravagant. And I can see the point of that. And having read their judgment and considered it more recently lately, like yesterday, it occurred to me, I was wondering whether one could draft a contract in the way that one sees contracts drafted in non-compete clauses. In non-compete clauses, often you see the clause saying, well, you can't compete for a year. Alternatively, you can't compete for 6 months. Or alternatively, you can't compete for a month. And I was wondering whether, and I'd be interested to hear what you think about this, whether you could, in a case like Mr. Kay's, say, well, the non-compete clause will be avoided if you make any default of any kind. Or, if that's void, the non-compete clause will be avoided if you fail to make a whole payment on time. Or, if that's void, the non-compete clause is made void if you fail to pay, let's say, 3 in a row. That would be awkward drafting, but it might be a means by which to protect a person in Mr. Kay's position from what ultimately happened, which really was that this clause that he said was one absent which he wouldn't have sold at all was struck down, and he didn't get from the bargain that which he thought he'd got. Thinking it through, a clause like the one I'm proposing would, in fact, also it may well be less of an incentive on the person who was due to pay the money than one otherwise, because the person would say, I've got a couple of options here. But anyway, there's a possible drafting point. A very different case, and one, I'll just try and explain to you what happened in the case, where you might think that Justice Brereton would take a different view than did the Queensland Court of Appeal. North Queensland Pipeline owns a 350-kilometre long gas pipeline which goes from wherever the gas fields are to among places where Queensland Nickel has its nickel refinery. And the deal is, if you want to transport gas, you've got to get your gas from somewhere. If you want to transport it to, say, your refinery, you enter a contract with North Queensland Pipeline and you can pump your gas through their pipeline and take it out at some end point. And the promise was that the pipeline owners would provide the capacity to transport X megalitres of gas per year. Now, there was a regime about something called the gas imbalance. So if you got gas from somewhere and put X megalitres in at the start point, but you took out less at the end because you didn't need to, in effect, if you think about it, you're asking the pipeline owner to store your gas. On the other hand, if you take out less gas than if you take out more gas than you put in, you're in effect using someone else's gas. And that's this thing called the pipeline imbalance, one of those intriguing commercial concepts that one only finds out about when one sees a case that's gone wrong. The contract provided that if there was any gas imbalance, whether it be positive or negative, and no matter whether it was a big one or a small one, something called a firm forward tariff, which was 200% of the daily fee used during the relevant period would be charged, and that was 22 big ones. 22 big ones. Now, the 4 judges in Queensland who dealt with it, the trial judge and the 3 judges of appeal, looked at the matter in great detail, and obviously there's lots of technical information one had to absorb, and it was held not to be a penalty. And I reckon if Mr. Kay's provision was a penalty, this one would be too. And I'm oversimplifying things, obviously, but and I don't pretend to have absorbed all the detail that the Queensland Court of Appeal absorbed about what happened in that transaction, but on the face of it, it appeared to be a very serious consequence, which could be, in some circumstances, out of all proportion to the gas imbalance in question. If it could happen for any imbalance, not a big one, well, minds could differ, I suggest. Almando. This is the case I did more recently, involving the penalty. This was a commercial lease. The main focus of the case was because it went pear-shaped during COVID. The Crocs Franchising Company was a childcare organisation, and as you can imagine, once the COVID pandemic hit in March 2020, things went very badly wrong for childcare centres. That's how things went wrong. The relevant provision was one which arose this way. When the lessor was persuading the lessee to lease the premises, it was part of the deal that the lessor would provide a $250,000 fit-out fee to enable the lessee to fit out. And the provision of the contract provided that if there was default, which I found there was, and if the lessor became entitled to recover possession, which I found it was, then a pro rata portion of the fit-out fee would have to be returned. And I must say, when I first looked at that, I thought, well, that looks fair enough. You've been given this money to set up the premises. You've set up the premises in a way that suits your business, may not suit the business of anyone that the lessor might wish to lease the premises to later. But looking at it more closely, the conclusion I came to was this, that in circumstances where default was established and the lessor was entitled to arrears of rent and also entitled to loss of bargain damages, reflecting the delay, and there was a long delay, you can imagine in COVID, a long delay in the lessor finding an alternative tenant. The result of being able to recover even, I think it was half of the $250,000, was that the lessor would end up being in a better position than it would have been had the lessee complied with its obligations under the lease. So I concluded in that circumstance that it was a penalty. But I must say, this does happen sometimes. I remember having to write two versions of the draft. That does happen, and often when you're not sure what the answer is. And just don't forget that what we have to try and find is the correct or preferable answer. Often there is no absolutely correct answer. On this occasion, it was one where I wrote the opposite result to the one I came up with, wasn't happy with it, actually wrote out the second, and came to the same conclusion. As I came to the conclusion I've just outlined. I was happy to do that because I later found out before I delivered judgment, there was a Queensland case which dealt with indistinguishable facts, and Her Honour in that case found it was a penalty, so it would have been a bit awkward if I'd not found that case. So there's like a personal life experience of mine, just dealing with what actually goes on when you're having to confront a contention that a provision is a penalty. And in the Almando case, there is an appeal on, but I think the appellant is the person who got the favourable result that it was a penalty. As you all know, we don't care about appeals. We'll do our job and we just move on. But we all do get overturned, except Rowan Dark, who never gets overturned, and that's why he's going so soon, while his scorecard is so good. But I'm diverting myself now. But there's no mechanism to tell us whether there's an appeal against us. You might find out just because your tippy finds out, or because you see something in the list. And the only way you get told what the result is, you're meant to get a copy of the appeal court's judgment with a comp slip, normally from the judge with the star, momentarily after the judgment's handed down. Often it's later that day, and of course we're all looking for the D word, dismissed, not the A word. But the most irritating one is allowed in part. That's so annoying. Anyway, so some practical steps, and this is, I hope, useful to those who are drafting clauses, but it's useful for those who are considering whether a clause can be attacked. First, identify the terms and inherent circumstances of the parties judged at the time of the contract. That's the important thing. And second, identify the event or transaction or the stipulation that gives rise to the imposition of the stipulation. That might be breach, but as Andrews has told us, it doesn't have to be breach. And then identify the stipulation that's payable on breach, and that obviously requires consideration of the substance of it, but what is the event that's said to be penal? And then identify if the stipulation is as a matter of substance collateral or accessory to the primary stipulation and imposes this additional detriment. Now, going to the next slide, if you go back to that, if the answer to 3 or 4 is yes, if it is yes, then the questions include, is the sum a genuine pre-estimate of damage if we're talking simply in dollar terms? Is it out of all proportion, exorbitant, unconscionable in comparison with the legitimate interest that's sought to be protected? And is the stipulation payable on the occurrence of one or a number of events of varying seriousness? And that was the point that Justice Brereton made about Mr Kay's position. It meant that the non-compete clause could go because of an egregious breach, just not paying the first instalment, or because of a trivial breach, $1 or $2 late on the last instalment. And is the sole or predominant purpose to punish the party for the breach. Just going back to what Justice Brereton said in Kay, what he said there was, this is apropos my finding, which has been made in many cases, that the clause was the subject of length of negotiation by water resource parties. He said that's not the point. The first question is it a penalty? And if it is, it is. And if it is, it isn't. And it doesn't matter how it arose. I'm not sure I agree with that. I'm not saying that the fact that a provision was the subject of heavy negotiation means it can't be a penalty, but surely it's relevant, I would argue, as to whether it might be. All right, so finally, practical tips. There are a few occasions where you can draft clauses to avoid them being penalties, a few I can think of. One common one, I think, is where an amount, there's a debt due, it's to be payable by instalments, but if you fail to pay one instalment, the whole comes due. I think it's well established that that wouldn't be a penalty. There's the, I think, familiar provision where interest rate is said to be 20%, but if you pay on time, it's 5%. Now that's, we're told, not a penalty. We all know what that really means. It means the interest rate is 5%, but if you don't pay, the default rate's 20%. But if you use the right words, the interest rate is 20%, but if you pay on time, it's 5%, then I think I've said no day in other cases, so that's not a penalty. And where a secondary provision is not truly collateral but simply identifies the essential nature of the primary transaction and spells out what the common law consequences would be of breach of the primary stipulation, then that wouldn't be a penalty. And what I'd suggest for those who are drafting these clauses is work out, does your client really need that secondary stipulation, the one that might be a penalty, to focus the other party's mind on the need to comply with the primary stipulation. That's it. Happy to have any questions.
Before we start, in Kay and Play-Up, was any consideration given to the fact that in a contract for the sale of a business, the payments were being made over time? So if there was a failure to make a payment towards the end of the payment terms, I assume there was a correlation between the fact that the restraint period was probably also coming to an end.
Yes. Well, yes. I wish I'd thought of that. That's a good point. Yes, because I'm forgetting. I think my memory is the restraint period was the 24 months. That is, while you're paying me off, I won't. But whether it was not, whether it was more, then obviously, as you say, as time went by, the duration of the restraint would be eroded pro tem.
Yes, well, Council should have thought about it.
The other thing, so should Paul Brereton.
The other thing that occurred to me was that if there was a failure to make one of the payments, that may be an indication that the purchaser was in fact going out backwards, which was going to leave the market vacant. And it was a legitimate thing for the vendor to say, well, if you're going to fail, I want to go back in.
I think I'll seek to get the case reopened. No, they're good points, Bruce. Please. So it just shows how minds can differ. How many?
Just staying on the K case, you mentioned some drafting propositions that you thought might have got around it, which was almost a kind of staggered falling away of the level of protection that was granted by the clause to the extent that each one's found void. I was wondering whether you might have, or whether you think the appeal court might have come to a slightly different view in circumstances where a cure regime was set alongside it. For example, if it was a technical breach, there were a few cents or a few dollars less for...
I'm having some trouble understanding you.
Oh, sorry. It might be the accent. I was wondering whether you thought a cure regime, in other words, upon the breach, particularly if it's of a minor or potentially innocent nature, if there was a notice regime a notice regime and a failure to then cure within a certain period following notice,
yes.
Whether you thought that might have changed the kind of the appeal court's mind?
Yes, because it might make it less unconscionable for the person with the benefit of the main provision to proceed. You're saying, in effect, you're giving them a second or maybe a third chance to fix the problem. Yes. There may be a number of drafting techniques one can use. I mean, the problem for we litigators is that we only see these problems once the balloon's gone up. And you're talking really about how to draft things to avoid there being a problem. And as I said earlier, I reckon that the only reason the word penalty comes into anyone's mind is that some solicitor or barrister thinks that might be a good argument to run in the case once things have gone wrong.
I'll just add a question about your previous slide. You had a few examples of cases that were unlikely to be a penalty. And it struck me that, especially with the first two, they seem to be discounts, effectively. That if you're offering a discount and you don't meet the criteria for the discount, we don't have to give you a discount. But, and I know that the Court of Appeal in Queensland had a different view on the alternative. But the alternative is if you're increasing the cost, well, that doesn't seem right, and that could be an unlawful penalty. And it made me sort of think, from a doctrinal point of view, do you look at discounts differently? Do you think that if someone is giving out of the generosity of or goodwill, giving a discount, that's something that's within their right and free will to do so, and at the moment that they try to double it or multiply it by 1.5, that's when you get to something that looks like a penalty?
Well, yes, I agree. That's the difficulty. It's but normally the provisions that are tagged as penalties are ones that have come about where the parties have agreed where risks are to be allocated. They've thought about it and they've come to a deal between themselves as to allocation of risk, and what you're saying is relevant to that. Victor?
This may not be a question for a trial judge, but an observation perhaps. Presumably the law of penalties is in a sense a common law protection aimed at unfair bargains, traditionally the Dunlop case. And the proposition that you observed that His Honour Justice Brereton rejected, that is the first starting point ought not to be whether or not there's been a a bargain fairly struck between well-advised, well-considered parties is not the starting point, but perhaps ought that become the starting point, given consideration now that there are many statutory protections for unfair bargains between essentially parties who are unable to protect their own interests, but where parties are able to protect their own interests and engage in proper negotiations, well-advised negotiations, and don't need protection, the penalty regime should simply not be applicable.
Well, I don't think I can abolish it as a trial judge, but you're right. The doctrine evolved when there was no consumer protection regime that we all know about. I mean, there is, under the ASIC Act and the Corps Act, there's a very broad provision to deal with unfair contracts. It's a very wide sphere. But the fact remains is that there's separate means by which you can attack provisions. Perhaps in my next judgment I should just simply abolish it. Because then, of course, I'll be aiming to get what Justice Hammersley calls the CARC, which is to become in the Court of Appeal Reversal Club. Now, I'm going to deny saying this if you tell me, but the dream is to be reversed by the Court of Appeal, preferably in excoriating terms, although that doesn't occur anymore, and then to be upheld 5-zip in the High Court. In a unanimous decision published within weeks in which they say the trial judge was plainly correct. So I'm not in the CARCA club yet. The Hammer's got 5, he says.
If I could ask on O'Dea, the example you gave of the 5 and the 20%, there's variations on that. Sometimes we'll give you the 5%. If you don't pay on time, it's not just 20% going forward, but 20% into the past as well. But I'm just curious whether you're aware of any decisions that seek to challenge or undermine or give hope that O'Dea may not be followed in the more egregious of those two illustrations.
No, I don't. Bernie would know. I don't know. I think it's well established that even though it's obviously artificial, but that's the position. Pritch?
I have a simple question, which is a simple loan contract where the interest rate's 200%.
David doesn't need a microphone.
In a simple loan contract where the interest rate is 200% or 300%, not reduced, why wouldn't that have scope to argue it's a penalty?
You mean by the mere fact it's so high?
The mere fact of the extravagant interest rate. If Andrews is right, does that have to be a linked breach?
You mean if you default, you've got to pay? You mean if the interest rate's 100%, even if you don't default?
Yes, that's what I'm saying. If you take Andrews at its highest and you say it's disproportionate, remedy, why wouldn't a 300% interest rate
itself? Itself.
Yeah, itself.
Well, I think because it's not payable contingent on another event is the answer. As Hutton SC just said, sotto voce. Now, I'm afraid I'm due back to continue the commercial list, so I'm going to have to leave you, I'm afraid. So, thank you for having me. And
thank you, Judge, very much for sharing your knowledge and insights. It's intriguing to know that even a judge would write two different judgments in coming to the conclusion, and I think shows us all that it's a tricky area of the law. So, thank you very much.
Never in a case that Pritchard's been in.
Judge, just one last thing before you go. Can you pick out the lucky door prize? No peeking.
What's the reward? David Pritchard, no. Catherine South.
This is yours. Thank you very much, Judge.
Thank you.